court will now hear the case of the IMT versus Eric Rader, led by Justice Charlie Leonard.
We will now hear the prosecution's opening statement. Prosecution, please approach the stand.
Good afternoon, Your Honors. Eric Rader, through the positions awarded to him, broke multiple pacts, treaties, and international laws, enabling the Nazi Party to use the German Navy as an instrument in their plans. Today, we are trying Rader on 3 counts: conspiracy, crimes against the peace, and war crimes. Rader became Chief of Naval Command and head of the German Navy in 1928, before the Nazi Party came to power. He became Commander-in-Chief in 1935, and a year later, General Admiral. 3 years earlier, however, he had joined the secret Reich Defense Council on April 4, 1933. The Reich Defense Council was a group of Hitler's inner circle created to plan and prepare for war economy. For example, economically mobilizing, rebuilding the German Navy, and planning attacks on other countries, even though they would be violating the Geneva Convention, the Treaty of Versailles, and the Kellogg-Briand Pact. At a conference on May 22nd, plans for developing and rearming the German Navy were set in place. Rader developed and supplied the Navy with weapons in secret to avoid the limitations of the Treaty of Versailles. The quote in document C-156, "The Commander-in-Chief of the Navy, Admiral Rader, had received hereby a far-reaching independence in the building and development of the Navy," which demonstrates how Rader was solely in charge of these efforts. Being in charge of rebuilding the Navy in secret, Rader made sure that the amount of auxiliary boats belonging to the German Navy were concealed from the British, ordering members of the Navy to refer to these boats as transport ships. A detailed log in document C-23, dated 1927 to 1940, that had notes on the reconstruction of the Navy, showed that the number of battleships exceeded what was permitted by the Treaty of Versailles. Rader, being Commander-in-Chief, General, and Admiral, had to be aware of the deception of the German Navy, if not involved in it. Additionally, Rader was heavily involved in attacks on other countries, including, but not limited to, Norway, Denmark, the USSR, England, France, and Belgium. Rader was extremely proud of the attack on Norway, saying in a letter to the Navy in document C-155, "The operations of the Navy in the occupation of Norway will for all time remain the great contribution of the Navy to this war," showing that the Navy was a key part to these attacks. All relations between Germany and the USSR are located in a file of naval notes. Rader was initially against the attack on Russia because of its inconvenient timing, but when Hitler made the decision to attack, Rader began to push for further involvement of the Navy. In document C-170, the entry on March 19, 1941, shows how Rader encouraged Hitler to involve the Navy in his plans for attacking the USSR, saying, "The Supreme Naval Commander describes the occupation of Murmansk as an absolute necessity for the Navy." Rader cannot deny his involvement in treaty-violating plans, as he was recorded to be a participant in a secret conference led by Hitler, discussing probable attacks. In this conference, Hitler made multiple statements about disregarding pacts, saying, "Declarations of neutrality must be ignored," and "Considerations of right and wrong or treaties do not enter the matter." These quotes can be found in document L-79. By preparing for war against these countries, Rader proves that even though he was very aware that it was against the law, the ideals of the Nazi Party were more important to him. The final charge for conspiracy is also a matter of war crimes. The Athenia was a passenger ship that was sunk in 1939 by a German torpedo boat, U-30. The crew on U-30 was sworn to silence about the sinking of this ship, but one member wrote an affidavit confessing to it. The logbooks, which were carefully kept with the records of all the ships that they had sunk, had no details from September 3rd, the day the Athenia was sunk. The page was obviously altered to contain false information in an attempt to cover it up, putting U-30 about 200 miles from the Athenia that night. Rader, being Commander-in-Chief, would have been well aware of the deception, proving that he had to be involved in these attempts to conceal the sinking. Now I'll pass it off to my co-prosecutor, Amelie Wong, who will be discussing war crimes and crime against the peace.
Hello, Justices. Concerning Rader's war crimes, one of his actions stands out more loudly than the rest. this being his order for and execution of the commando order. Hitler ordered for all commandos to be shot on sight without exception. Under Raeder's command, the Navy executed this order. Raeder denied the protection of the Geneva Convention to commandos by killing them on sight without opportunity for fair trial. It cannot be permissible for a person to be responsible for death through the commando order and get away unpunished. While executing the commando order, Raeder continued to commit war crimes through his attacks on shipping vessels. As stated earlier, Raeder is responsible for attacks on the passenger ship Athenia, which also makes him guilty of war crimes. In document UK 65, Raeder himself stated that the Navy's, quote, naval strategy will have to employ all the military means at their disposal as expeditiously as possible, end quote. This clearly displays his complete disregard for international law and willingness to act on aggression. Regarding Raeder's crimes against the peace, Raeder violated the Kellogg-Briand Pact, the Non-Aggression Pact of August 23, 1939, and the Versailles Treaty through his actions in the Navy and as a Nazi. Raeder violated the Treaty of Versailles by personally expanding the Navy, as stated by my fellow prosecutor earlier. He also violated the Kellogg-Briand Pact by waging war and acting on aggression. His involvement and contributions to the Secret Reich Defense Council and the Secret Advisory Council for Foreign Affairs highlights his role in furthering Nazi ideals through aggression. Along with these councils, Raeder was also a participant at Hitler's meetings, including two where he openly stated his plans to attack other countries. By participating in these meetings, Raeder supported Hitler's plans and helped him to further Nazi objectives, even though they directly defied treaties that Germany signed. Waging war against Russian forces violates the Non-Aggression Pact. Raeder had been planning the Navy's participation in attacking Russia, and therefore he violated the pact. As stated in document C-170, quote, on the proposal of Chief Naval Operations, use of arms against Russian submarines is permitted immediately. Ruthless destruction is to be aimed at, end quote. These attacks against Russian forces were always discussed with the need for secrecy. This need for secrecy in Soviet submarine plans and within his secret councils highlights Raeder's knowledge of his violation of international treaties and pacts signed by Germany. To conclude, this is a case about a Nazi who broke international law. As a Nazi, Erich Raeder played a big role in the party's inner conspiracy, helping to create and execute their plans. As an admiral, Erich Raeder filled the role of a leader, commanding orders that promoted Nazi ideals and coercing others beneath him to do the same. Under Raeder's command, naval soldiers executed the commando order and shot commandos in a plain act of murder. This execution in support of the commando order makes Raeder guilty of denying the protection of the Geneva Convention to prisoners of war. Raeder's negligence for official law was also apparent through the Navy's actions at sea. By requesting and following through with attacks on neutral shipping, Raeder demonstrated this habit of disregard, which continued to go on throughout his career. It is obvious that Raeder was a close comrade of Hitler. From one-on-one meetings to the new title of Grand Admiral personally bestowed onto Raeder, their relationship reflects Raeder's success in the inner Nazi system. This success allowed for Raeder to be a participant of many of the Nazis' inner secret councils. It is clear from his attendance at these meetings that Raeder was one of the top most influential Nazis who actively planned to wage war against other countries, and therefore broke international treaties and agreements signed by Germany. The Kellogg-Briand Pact, the Non-Aggression Pact created on the 23rd of August 1939, and the Treaty of Versailles were all violated by Raeder through his roles in the Navy as a Nazi. The Treaty of Versailles in particular was one Raeder had no regard for. He violated it by acting on aggression through war and his personal influence on expanding the Navy past the limits allowed in Versailles. While many things can be said about Raeder, it has been clear from the start that Erich Raeder violated international law. For that reason today, through all this evidence and more, Raeder will be found guilty on the counts of crimes against the peace, war crimes, and conspiracy. Thank you.
We will now hear the defense's opening statement on behalf of Mr. Raeder. Defense, please approach the stand.
Do I have permission to request an additional 60 seconds from my closing statement to my opening statement? Noted. Great, thank you. Good afternoon. My name is Lane Rashevsky, and I'm representing Eric Rader in this monumental case. The defendant stands here, falsely accused of conspiracy, crimes against peace, and war crimes. At the conclusion of this case, we ask for a verdict of not guilty. Defendant Eric Rader is being prosecuted under unwarranted circumstances. Commander Rader did in fact support and administer the rearming of the German Navy. He requested that the Navy budget should be increased multiple times and was a key factor in rebuilding Germany's naval power. The rearming of the German Navy was in fact illegal under the Treaty of Versailles, which limited the tonnage of the German fleet. However, Your Honors, consider the fact that the Treaty of Versailles completely ignores the principles of national sovereignty. The majority of European countries have agreed to live by the terms of national sovereignty. In other words, they have agreed to give other nations independence to rule over themselves. The Treaty of Versailles of Westphalia, also signed by many European countries, also allows every nation to have complete sovereignty over their territory, which the Treaty of Versailles violates. The victorious countries of the previous war restricted the navy of another country. By restricting the German Navy under the Treaty of Versailles, they prevent Germany from truly being an independent nation. Under the dire circumstances of war, Germany would have been unable to defend itself against its enemies. A nation unable to protect itself is a nation unable to protect the lives of innocent civilians. Eric Rader rearmed the Navy for the sole purpose of defending his country, not because he believed in a Nazi conspiracy. According to Statement 7, the German Navy was legally granted increased military expansion by Britain in the Anglo-American Naval Agreement and allowed to have the same number of U-boats as Britain. Eric Rader should not be held accountable for exercising the right to maintain a military in a world where national sovereignty is accepted and valued. Eric Rader has also been accused of violating the terms of the Kellogg-Briand Pact, where most countries outlawed war in 1928. It is unjust to penalize Rader for violating this act because it has been violated multiple times by other countries. For example, Japan invaded and moved in China in 1931 with thousands of casualties. This is listed in the evidence book. No punishment was enforced because the U.S. did not want to start a conflict and wasn't in the financial state to prosecute. Now, as a victor of this war, they feel the need to prosecute a mere naval commander for violating terms that have clearly not been enforced in the past. Commander Rader violated the Non-Aggression Pact signed between the USSR and Germany, but had previously tried to avoid the invasion completely. Commander Eric Rader and his staff were reluctant to invade the USSR, Norway, and Denmark. According to a memorandum from Rader and an affidavit by Dr. Otto Gessler, he continuously tried to prevent Hitler's plans to invade those countries, but felt compelled to agree to Hitler's plan. In a time of war, a commander is expected to carry out his naval duties in order to protect his country. The prosecution also presented a piece of evidence regarding Rader's positive thoughts about the Norway invasion. We simply cannot prosecute someone for thinking someone else's plan is a good idea. Eric Rader was falsely accused of sinking the passenger ship Athenia. Oberlieutenant Lemp was in charge of the U-boat that fired the torpedo and mistook the passenger ship as an enemy vessel. Sea warfare is an extremely difficult and dangerous action, and Oberlieutenant Lemp took precautionary measures to protect his crew. Rader cannot take responsibility for the missteps and mistakes of his underlings at sea. In fact, Admiral Dönitz admitted it was only under his orders that U-boats keep a lookout for armed merchant cruisers. Dönitz was a true Nazi who continuously tried to combine the Navy with the Nazi Party. Rader was solely concerned about protecting his country and his people. Commander Rader is being charged for breaking the Geneva Convention rules and issuing the order to shoot commandos. Rader did not issue the shooting of commandos and did not enforce any punishments or on any captured prisoners, nor can the prosecution prove otherwise. Moreover, according to Statement 1, the commander rule issued solely by Hitler did not apply to captured prisoners at sea. Rader cannot control Hitler's release of orders and cannot be charged with the fact that Hitler was aware that this order would break the Geneva Convention. Rader, being a naval commander, had zero contact with the order and the chain of command because the order was not applicable to his job and is therefore irrelevant to this indictment. Rader actually ordered his naval fleet to save Allied survivors at sea. This clearly is an act in support of the Geneva Convention, and not the commander role he is being tried for. Eric Rader is being accused of attacking neutral shipping vessels and breaking the Geneva Convention. Rader should not be punished for crimes also committed by other countries. According to the U.S. Fleet Admiral Nimitz from Evidence during 1900, the U.S. partook in unlimited destruction of enemy forces, and yet is here prosecuting my defendant. Clearly, attacking neutral shipping vessels was common practice between all opposing countries in the fog of war. Rader's underlings also mistook neutral shipping vessels as enemy ships and took defensive measures to protect themselves and their crew. Rader cannot be held responsible for his underlings' errors at sea. Commander Rader is simply being prosecuted for his ideas about military planning and naval strategies. As a naval commander, Rader is expected to provide planning for future military actions, as any naval commander from the Allied countries would. Rader is expected to take precautionary measures to protect his country and his people against the enemy, especially in a time of war. Rader's ideas and plans have no clear connection to the goals of the Nazi Party. Commander Rader cannot be associated with the other participants in the war meetings he attended. It is extremely important to understand that Rader does not share the same beliefs as his comrades. According to Rader's Statement 9, his sole intention of directing the Navy was to protect his country, with no cruel Nazi intentions attached. As a modern society founded on contemporary legal principles, we cannot exercise guilt by association because of a person's presence at a meeting. It is a far reach to say someone is guilty of a crime for attending a meeting where leaders discuss the protection of their sovereign nation. Commander Rader was present at rights defense meetings, but the prosecution has no evidence claiming he was an active participant. In the minutes of the meetings, the speaker was not specified. Rader was able to attend any meeting that occurred because it was his job to stay informed about military actions. Following the idea that guilt by association is unjust, Rader cannot be held accountable for the ideas proposed by others at his meetings. He has no control over the words spoken by Hitler or his comrades. I would like to bring a piece of evidence presented by the prosecution to your attention. They claim that Rader was present at a specific rights defense meeting on April 26, 1933, and furthermore, hold him accountable for the ideas discussed during the meeting. This is simply inaccurate. If you look at the participants that were present during the meeting on evidence EC 177, Eric Rader is not listed and therefore cannot be held accountable for the ideas discussed. Let me repeat the most important points of my argument. Commander Rader cannot be held accountable for the limitations of the Versailles Treaty because it restricts the sovereignty of a nation, of a country. Nations should be allowed to remain independent and, most importantly, have the ability to protect themselves. The German Navy was also legally granted military expansion by Britain. Commander Rader was extremely reluctant to invade Russia and did everything in his power to prevent the invasion. The order to shoot commandos was issued only by Hitler and had no relation to Rader because the order did not relate to any prisoners captured at sea. Rader had nothing to do with the sinking of the Athenia, as the entire operation was under the control of Admiral Dönitz. The destruction of neutral shipping vessels was common practice in a time of war. Rader's ideas cannot be persecuted, as he should be allowed to speak freely. Planning an invasion is common wartime duty, and it was clearly Rader's job to plan invasions. Rader's presence at meetings is not prosecutable, and his attendance was only to stay informed about military actions, which is his purpose in the Navy. There is no evidence showing that he contributed to any of the meetings, so the prosecution cannot prove any of his ideas were executed. He did not attend the rights defense meeting on April 26, 1933, and cannot be charged based on this fallacy. I know you may be tempted to lump Eric Rader into this group of cruel Nazis, but above all, you should remember that Rader does not share the same beliefs or opinions as any of his contemporaries. Rader's intentions in serving the Navy were pure and simple, to defend his country and protect the German people. At the conclusion of this case, we would ask that you find my client is innocent of the charges of conspiracy, crimes against peace, and war crimes. The prosecution is not able to provide the appropriate evidence to support their reasoning. They offer baseless arguments that are emotionally driven. Thank you.
We will now hear the defendant's plea. Mr. Rader, you may begin.
Good afternoon, Your Honors. I'm Grand Admiral Eric Rader. I've been falsely accused of conspiring to and committing crimes against the peace and war crimes. I'm here right now to inform you about what exactly happened in my past and why the prosecution's arguments are flawed. I was a German naval officer who joined the Navy at a young age. I eventually found myself becoming the head of the Navy in 1928 and continued to lead the Navy for 13 years. Like many in Germany, I was loyal to my country and wanted to fight for it. I spent 46 years as an officer of the German Navy. During that time, Germany had 4 different governments, and I served them all dutifully. I'm a proud and hardworking man who worked my way up the ranks of the German Navy. I was always willing to do whatever I felt was necessary for Germany to win the war, the same way my enemies were. The prosecution has accused me of conspiring to break the peace by helping to make a plan to invade Poland and for being present at political meetings where Hitler showed his intent to invade neighboring countries. This was not my plan or decision. What choice did I have? It was a direct order from the leader of my country. In 1943, I was given the title of Admiral Inspector, effectively taking away my control of the Navy. I was forced into retirement because I suggested that we should not invade the USSR in 1941. Hitler invaded Russia against my country. As we know, Hitler's plan to attack the USSR failed, and my attempt to resist Hitler's plan was rewarded with retirement. I knew that resisting the plan to attack Poland would have had the same result. Why should I be responsible? Why should I be held responsible for doing my job? Yes, I was at the meetings where Hitler informed us of his plans to invade neighboring countries, but I did not show any intent or participate in any meaningful matter during the meeting in general. Like I said earlier, I even suggested that we should not invade the USSR and was ignored. I helped plan an invasion of Poland when we realized the growing friction between our 2 countries could one day lead to an armed conflict. Although planning for this contingent invasion might have been premature, it does not make me guilty. The prosecution has inaccurately accused me of conspiring to and breaking the peace by rearming the German Navy after the Treaty of Versailles. During the rearmament of my Navy, I did conceal the true number of ships and the size of the Navy, but I did not conspire to or break the peace by rearming the Navy. I was simply trying to put my home country in a position to protect itself in the water. I ask you to consider how unreasonable it is to expect us to continue to abide by a law that restricts our country's right to protect ourselves from any of our enemies. The cap of 100,000 soldiers, just 15,000 sailors, is simply absurd. When I was ordered to take part in this rebuild, I did what I thought was best for Germany. It was a defensive move made solely to protect Germany. It is also alleged that I committed war crimes because I was in command of the Navy when my officers followed an order by Hitler to kill all enemy commandos that we captured. Although some of the officers that committed this crime were a part of my Navy, none of the killed commandos were captured at sea. I did not order, take part in any way, or even condone the killing of the commandos. Inferring that I took part in or was responsible for the killings of the commandos just because I did not object to Hitler's orders is an unfair argument. Hitler is responsible. Although I wanted to object to the murder of these commandos, there's no way I could go against Hitler without being in serious trouble and at risk of being executed for insubordination. In a letter, Hitler even remarked that if anybody acted against his order, they would be executed. I did not take part in or do anything that would warrant finding me guilty of these war crimes. I was forced into retirement because I did not agree with Hitler's decisions. In this instance, with no difference. Although I did violate the rules of the Geneva Convention by having my Navy attack neutral ships that were delivering resources to England and the US, I should not be prosecuted for a crime that the victors of this war also committed. Some of these ships were also formally neutral when transporting soldiers or weapons. My Navy was just one of many in the war that attacked neutral ships. In fact, as my attorney said, the United States was a very active contributor to the destruction of ships. I was just trying to give my country the best probability to win the war. By attacking neutral ships, I was improving my country's odds to win. I am positive all of the other naval commanders have the same thought process when they attack neutral ships. It would be unfair and hypocritical to hold me accountable for actions taken by all parties in World War II. The prosecution's arguments are inaccurate, unfair, and full of crimes that both sides of the war committed. Most of the evidence against me violates Germany's sovereignty and takes away my country's right to protect itself. In conclusion, I ask you to recognize the invalidity of the prosecution's case and find me innocent. I fought for my country, nothing more. Thank you.
We will now begin direct examination. Defense, please approach the stand.
Commander Rader, what were your intentions of rearming the German Navy?
My sole intention was to protect my country and people. I recognized the growing conflicts in Europe at the time and did what I thought was best in order to protect Germany.
Did you take into consideration that the Treaty of Versailles was being violated when rearming the Navy?
I did take the Treaty of Versailles into consideration when I was commanded to rearm the Navy. However, I decided that it violated my country's sovereignty and took away Germany's ability to protect itself from any enemies.
Were you ever granted an expansion of the Navy by allied countries?
Yes, I was. The Anglo-German Naval Agreement allowed me to expand the Navy's fleet. This agreement also shows that England recognized the extreme unfairness of the Treaty of Versailles, and therefore proving my actions to be reasonable.
Why did you violate the non-aggression pact against Russia?
I did not want to violate the non-aggression pact against Russia, and I strongly advised Hitler not to invade Russia. However, when Hitler decided to go against my advice and invade Russia, it was my job as the head of the Navy to listen to the head of Germany and employ my Navy against a threatening enemy.
What is your connection to the sinking of the passenger ship, the Athenia?
I do not have a connection to the sinking of the passenger ship Athenia. The U-boat that shot down the Athenia was commanded by Admiral Karl Dönitz, and I had no contact with the Athenia or anything that had to do with it.
Did you deny the protection of the Geneva Convention by following the commando order?
I did not deny the protection of the Geneva Convention. The commando order was given by Hitler. It did not pertain to any commandos caught at sea, and I did not command it to any of my naval officers. Therefore, it did not pertain to my job.
What is your perspective on the neutral shipping vessel violations? Do you believe you should be punished for these actions?
The attack of neutral shipping vessels was a very common occurrence. Was common practice before the war and during the war. I did not feel I should be singled out for an action that was carried that every country in the war also committed, including the United States and the United Kingdom.
Why did you attend the war planning meetings?
It was my job as the head of the German Navy to stay informed about military actions.
Were you a main contributor to many of the meetings you attended?
No, it was not.
Do you believe your plans or any of your general military ideas were valued and seriously considered? If not, are there any specific examples showing disregard to your opinion?
I do not believe my plans or ideas were seriously considered by Nazi leadership or Hitler. As I mentioned earlier, when I suggested to Hitler that we did not invade Russia, my ideas was ignored and he went on with invasion anyways. This was a common occurrence. This was common.
Commander Rader, did you attend the Reich Defense meeting on April 26, 1933?
I did not attend the Reich Defense meeting on April 26, 1933.
Do you have any connection to the Nazi Party?
I did not consider myself connected to the Nazi Party. My beliefs did not align with the Nazi Party. And when I heard of the atrocities that were being committed in the concentration camps, I returned my Medal of Honor and retired shortly after.
Thank you.
We will now begin cross-examination. Prosecution, you may begin.
In document 503 PS, which is a letter from Hitler received by you, it says that, under all circumstances, commandos be ruthlessly exterminated. Were you aware that this is a war crime and violates the Geneva Convention?
I was aware of the war crime. However, I did not order
In this
the
same letter,
officials to kill them and did not kill any of them.
In this same letter, it says, under no circumstance can it be permitted that a dynamite, sabotage, or terrorist unit simply allows itself to be captured, expecting to be treated according to the rules of the Geneva Convention. Did you or did you not refuse to follow this order? It's a yes or no question.
I did neither because the order was not given to me.
Also in document C-179, it says that all commanders and officers who acted against this order where it was to be executed. Are you or are you not a naval commander?
The order was not given to me, and just because I did not object to it does not mean I went through with the crime.
Are you or are you not a naval commander?
I am a naval commander.
Are you or are you not alive today, proving that you did not defy this order?
Just because I did not defy the order does not mean I partook in the order or killed any of the commandos.
Moving on. An article published for your birthday states that you are the first and foremost naval collaborator of Hitler. Is that correct?
I was the head of the German Navy, yes.
Does this mean that you were aware of the aims of the Nazi Party?
I was aware of what Hitler wanted to do.
According to the translation of document EC-177, the secret Reich Defense Council communicated by word of mouth in order to keep their plans secret. Are you aware that the work of this council violated the Geneva Convention?
Yes.
In document C-127, Hitler agrees that neutral ships should be sunk without warning. Were you aware that sinking neutral ships violated international law, even if considered common practice?
it was considered common practice because
Are you
every
aware
single
that
country in
sinking
the war
neutral
participated
ships
in it.
violated international law?
Yes, but so did every other, so it was common practice in every country in the war partook in this stuff.
In document UK 65, you say that military measures must be carried out even if they were not covered by international law. Can you clarify what you meant by international law?
Yeah.
Thank you. In document 655, why did you request for the name Raider to still be associated with the Navy?
Because I served the Navy for 46 years and I did not want my legacy to be forgotten.
In document C29, you said, "It is just when the efforts to do away with the restrictions imposed on us have succeeded that the German Navy has an ever-increasing and really vital interest in furthering the German armament industry." Can you clarify what you meant by restrictions?
The Treaty of Versailles, which unjustly restricted the German Navy and took away our sovereignty and our ability to protect ourselves.
In document C141, you say that, in view of Germany's treaty obligations and the disarmament conference, steps must be taken to prevent the first E-boat half flotilla from appearing openly as a formation of torpedo-carrying boats. Can you confirm that by treaty obligations, you meant the Treaty of Versailles?
I did, however, I did not conceal these torpedoes because I wanted to violate the Treaty of Versailles. I did this because no country that was paying for or had war openly gave information about where their weaponry or ships were located.
The quote from document C156 states that the Commander-in-Chief of the Navy, Admiral Raeder, had received hereby a far-reaching independence in the building and development of the Navy. Did you use this independence to develop and rearm the German Navy in secret, violating the Treaty of Versailles?
I did rearm the Navy. However, I was protecting my country's sovereignty, and I had no intention to break the peace or conspire to break the peace when doing this. I was just doing it to defend my country.
Thank you. That's the end of our questions.
Tribunal will begin question.
Mr. Rader, how would you define your relationship with Hitler?
Associate.
Mr. Rader, were there any attempt at reparations for the attack on the Athenia?
I had nothing to do with the Athenia, and
But were there any attempts at reparations for the attack?
it did not pertain to my job. I was not in command, or I did not control anything to do with that situation.
We'll now hear the prosecution's closing statement. Prosecution, please approach the stand.
To conclude, Eric Raeder violated international law through his acts in the Navy and as a Nazi. He is guilty on accounts of war crimes, crimes against the peace, and conspiracy, and for them he must be punished. Regardless of his intentions, Raeder continued to develop and expand the Navy, which is a direct violation of the Versailles Treaty. This fact has been proven through document C-156 and in our cross-examination. The Treaty of Versailles is completely enforceable. It is clear from Germany's signing of it as an international treaty that Germany agreed to its terms. In regard to the Treaty of Westphalia, Germany gave up the sovereignty granted to them by signing the Treaty of Versailles. As the naval commander of Germany, Raeder is accountable under treaties that Germany signed and must be found guilty for its direct violation of the Versailles Treaty. We are not here today to debate the fairness of the Treaty of Versailles. Rather, we are here to debate whether Raeder is guilty of breaking the treaty, and he did. The Kellogg-Briand Pact is also completely enforceable. Even if other nations are not being tried for violation of this pact, Germany still signed it, which makes Raeder's violation of it illegal. The Kellogg-Briand Pact outlaws war. Raeder cannot claim to be defending himself, as Germany was the one to initiate attacks. By attacking other countries and planning for war, Raeder is in direct violation of the Kellogg-Briand Pact. Raeder was also not against aggressive war on the USSR. Rather, he was upset at the timing that Hitler had decided for it. As stated in document C-170, Naval Supreme Commander recommends putting off Russian conflict until the time after the victory over England, end quote. Even so, Raeder was always looking for an active position for the German Navy and attacks on the USSR, as stated earlier in our opening statement from the same document C-170. Raeder cannot claim to be acting in defense, since Germany attacked the USSR first. In document C-155, Rader stated that their operation of the Navy in occupation of Norway will for all time remain the greatest contribution of the Navy to this war. Rader was proud of the Navy's contributions in furthering war efforts and acting on aggression. Its planning for and execution of war against other countries, including Norway, was a key part in its violation of the Calabrian Pact. The defense has claimed that Rader was not present at a meeting of the Reich Defense Council, but they are incorrect. While Rader was not mentioned by name, his title, Head of Marine Division, was referenced in document EC-177. Therefore, his presence at said meeting cannot be disputed. All of the meetings of the Secret Reich Defense Council and the Secret Advisory Council for Foreign Affairs had high-ranking officials present, and they had the power to enact change within war and inside Nazi Germany. By participating and giving his opinion on Nazi matters, Rader gave his knowledge and professional skill to Nazi war efforts and planning. Rader stated himself in document UK-65 that decisions made in councils would, quote, be adhered to under all circumstances, and under no circumstances once it has been made, be dropped or released, end quote. This quote highlights how Rader's participation in said councils and meetings would be very effective in enacting change to actions and plans of war. As stated by Rader during the cross-examination, Rader was aware of these councils' direct violation of the Geneva Convention. Yet, he still continued to attend and participate at these meetings. Rader's participation leads him to act on aggression through planning for war, and this leads him to be a big influence in the Nazis' inner conspiracy. As head of the German Navy, Rader had full knowledge of the Navy's actions and was responsible for said actions through his roles as Commander-in-Chief, Admiral, and General to the Navy. As stated in our cross-examination, document 503 PS details a letter that Rader received as commander to the Navy from Hitler explaining the commando order. Rader himself decided to implement the commando order into the naval system. An instance where the commando order was executed under Rader is seen in document C-176. The document states that before naval staff executed the commando order, they had been, quote, directed to get approval direct from headquarters, end quote. Rader was certainly aware of the execution of the commando order through the chain of command and is responsible for ordering and enabling it. In relation to the sinking of Athenia, due to his positions, Rader would have been aware of all the actions on his boats in his fleet, and he would have caught discrepancies stated by Luck in document D662. Therefore, he was certainly involved in the concealment of Athenia's sinking. Again, as you've seen and heard through our document book, our cross-examination, and all the reasons just stated plus more, Rader is evidently guilty of committing crimes against the peace, war crimes, and conspiracy. Thank you.
We will now hear the defense's closing statement. Defense, please approach the stand.
I am defending Eric Rader against the charges of conspiracy, crimes against peace, and war crimes. In the case before you today, we ask that you return a verdict of not guilty. The prosecution has failed at providing sufficient evidence and instead are relying on emotional and factually devoid arguments. For example, the prosecution has misapplied the law relating to the commando order. The commando order did not apply to prisoners captured at sea. Rader is an admiral of the Navy and could not have followed an order that was not applicable to him. Furthermore, Rader is not connected to the sinking of the Athenia because he was not in charge of the operation. Additionally, the prosecution lacks sufficient evidence proving Rader contributed to war council meetings, and therefore he cannot be held accountable for anything that was discussed at these meetings. We cannot charge Rader for the actions of an entire group. Sovereignty is a fundamental right that every nation should have that encompasses freedom and self-governance. Imagine a world where people are expected to sit by and watch as their country is conquered because they are not allowed to protect themselves. Rader cannot be prosecuted for common practices such as cover-ups for sinking of merchant ships, as other allied nations are not being tried for similar crimes. Rader is unfairly grouped together with other cruel Nazis. Guilt by association is not a crime, as Rader did not remotely share the same beliefs as other Nazi war criminals that this tribunal is trying, and had no affiliation with the inhumane beliefs of the Nazi Party. Highlighting the point my defendant made in his direct examination, he removed his Medal of Honor after hearing about the appalling actions of the concentration camps. For a high-ranked military man, this enormous action of removing an honor bestowed upon him shows Rader's disgust towards the Nazis' activity and separates him from the general objectives of the Nazi Party. While the Nazis as an entire organization partook in extreme and inhumane criminal activity, it is clear that Rader's affiliation with the party is solely pertained to military actions to protect his country. The prosecution has not proven Rader is guilty. We ask you to decide the only verdict that is fair, not guilty. Thank you.
The court will now debrief after hearing the prosecution and defense arguments.
All of the court rise.